Hello, I'm Stephen Goldie, author of The Return of Breaking Law, the book What I Wrote. I love this place, 400 grand, complete in 4 weeks. You sure you're okay for the mortgage? No problem, mate. Spoke to a broker yesterday. They can't wait to hand the money over. And you'll take the house off the market, eh? Oh, sure, I'll speak to estate agents as soon as you've gone. We'll shake on it. Probably a farrago of lies. That's how it is with buying and selling homes. More porkies than a bacon factory. Until contracts have been exchanged, either side can drop out and would have to bear the expenses they've incurred themselves. That's likely to be legal bills on both sides, and for the would-be buyer, the fee for a surveyor to go in at least. Exchange of contracts? Well, that's once both sides are able to be committed. Dependent transactions ready to be dovetailed, finances sorted, buyer satisfied the property isn't due to be knocked down to make way for a motorway, and that neither a fish and chip shop nor a public convenience are due to be erected next door. A formal document setting out the transaction details, including when completion will take place and seller gets their money and buyer moves in, will have been prepared in duplicate. Seller signs one copy, buyer signs the other copy, and they're swapped round. Exchange of contracts. Cool. If either drops out, then it could cost them heavily. Back to those lies. The seller's desperate to secure a buyer and the buyer's desperate to secure a new home and eliminate any competition. That's the reason for them. But an exchange of contracts may never take place. The seller may keep a property on the market and extract a higher offer from someone else. GAZUMPING may call that in all the best estate agencies. Or the buyer may drop the price that was agreed. Oh dear, oh dear, oh dear, it's come in, the survey report. Says the house is overpriced, back door handle loose, kitchen out of the arc, might be damp, may not get permission for a drop curb. Sorry, but this could all cost a fortune. You're going to have to reduce the price by at least 5 grand. No, that's what they call gazundering. There's a way to discourage gazumping and gazundering, and also to protect against lies and bad faith which could lead to financial loss. It's a lockout agreement which is made early and before contracts can be exchanged. For a specific period, maybe 6 weeks or so, the seller agrees that the property should be off the market and that they won't negotiate with anyone else, and they get on with the paperwork through their conveyancer. And the buyer agrees to do their best to instruct their conveyancer and get on with their mortgage application. Then, if either side breaks their promises or withdraws or fails to exchange contracts by the deadline, they have to reimburse the other side for the specified expenses they've incurred and which would have been wasted. These are the bare bones of the lockout agreement. You'll find a template for it in my book, Return of Breaking Law. There he goes again, plug. A man's got to live. The paragraphs of the template can be mixed and matched. The agreement could even be varied to cover each side paying over a modest deposit. This would be held by a third party, and should either side not do the business, the other would be entitled to take the entire sum which has been held by the third party. This Stephen Goldmabel is living in cloud cuckoo land. Now, I grant you that if you come up with the idea of a lockout agreement, the seller might tell you to get on your bike and drive away very fast until you're confronted by a row of climate change protesters, and the seller's estate agent will probably do the same. It's worth a try. Whether the seller's prepared to go along with it is going to depend on whether it's a seller's market at the time or a buyer's market. If it's a buyer who's being asked to sign the agreement, there'll be other considerations. How confident are they that the mortgage will be forthcoming? If they're worried about an adverse survey report, then the agreement can allow them to withdraw in that eventuality without having to pay over any money. Even if the idea of an agreement is rejected, the reaction of whichever side it is saying no could be instructive. If the blood runs from their face and they look as though they're about to attack you, you may wonder whether they can be trusted. There's an alternative to a lockout agreement, and that's an option to purchase. More of that in my book, Return of Breaking Law. Say you're the seller, the property's on the market through an estate agent, you only have to pay commission to the agent if the buyer came through them. However, your particular buyer is adamant they weren't introduced by the agent, never visited the agent, never received the agent's particulars or saw the particulars in their window, never saw a for sale board. So that will save you £629 in commission, inclusive of VAT. Knock that off the price. And say you agree, and it turns out that what you were told was untrue. The agent was involved in some effective way, and you have to pay commission after all. Well, you'll find a template agreement in my book to cover that situation. It provides for the buyer to reimburse you for the commission you had never expected to pay. I hope none of this has put you off moving. Do take care.